In 1975, when I was serving as National Field Director of SCLC, where I was raised up by Reverend Hosea Williams, I broached Dr. Ralph David Abernathy, our president, about taking on the judicial branch of government. I said, Dr. Abernathy, you know, we're focusing on legislative branches around the country, Congress. We're always looking at the executive branches, the President of the United States and governors and, you know, mayors. And I said, Dr. Abernathy, we got to do something about the judicial branch. And I said, right here in the state of Georgia, where SCLC is based, you know, we're almost 30% of the population, but we are over 65% of the inmates in the jails and prisons. And he said, well, what do you want to do? I said, I think SCLC ought to take on a project to bring either a lawsuit or do something to call attention to this problem. And so the conversation went on and on and on, and I ended up in the General Assembly because of him and Hosea Williams and Reverend Joe Boone. And then I began to talk about it even more. And finally, after Lachlan McDonald, my brother here, who has been with us since 1981 in this battle, he had won a reapportionment case for us at the U.S. Supreme Court that created the first majority black congressional district in this state, the 5th congressional district in Atlanta. We had 10 districts then. We wanted 1 out of 10. The state legislature, all Democrats, said no. The governor said no. We had to sue, and we won. And that's why John Lewis is serving in that seat today. And so from there, we began to talk about the judicial branch of government. Lachlan and I were working on the creation and revitalization of Keysville, Georgia, now between Augusta and Waynesboro. And I kept telling Lachlan, we got to do something about Georgia's judiciary. And finally, Lachlan went to the National Board of ACLU in New York, and he put it on the table. And the board said, well, if Tyrone is willing to be the lead plaintiff in such a piece of litigation, a complaint against the state, we'll finance it. The foundation of ACLU will take it on. And Lachlan brought the verdict back to me, and I said, okay, I'll do it, but I gotta have a coalition of people around the state. And we reached out across the state, and we found warriors from the NAACP and SCLC, and farmers and housewives and teachers and preachers, and we brought them in as co-plaintiffs. So we filed our case in the Southern District in Savannah. Judge A. Van Edenfield was the presiding judge over our case. Governor Joe Frank Harris was the governor when we filed the case in 1988. Governor Zell Miller inherited the case when he won in 1990. And so Governor Miller, before he was sworn in, called me up on the way from Young Harris down to Atlanta one day, and he said, Tyrone, I want you to know I'm going to be more responsive to this case that you all have filed. He said, I've inherited. He said, but I want you to know we need to settle it. He said, the case is based on merit. He said, there's no way we can go forward with the small number of African Americans serving in the judiciary across this state. He said, I haven't been sworn in yet, but you and I need to start talking now so that we can lay the foundation for negotiation. So I called Lachlan and told him that the governor called and we wanted to begin some discussions. And Zell Miller was the first governor to convince me, Gail and Sandra, to come into the mansion. I had never been in the mansion. I resisted going into the mansion for obvious reasons, but he convinced me to come in, and I did. And we sat in the kitchen of the mansion one day, and we began to talk about a framework in which we could have discussions going forward. We began to talk, and of course we had to rely on our lawyers, Lachlan being my lawyer and Mike Bowers being the state attorney. We began to talk, and we used the conference room of Senator Sam Nunn down at the Richard B. Russell Federal Building. We had to agree on a mediator, and we agreed that former federal judge who's now in heaven, Judge Anthony Alimo, would be our mediator. So we began the process of discussions that would lead us to a settlement because we knew we were not going to be successful in litigating it all the way through because of Judge Edenfield. He was just opposed to everything we were trying to do. And finally we got down to a framework which involved not only creating more opportunities for African Americans to become judges in circuits around the state that were 30% or above, but I put on the table, I said, listen, we've got to talk about the Judicial Nominating Commission, the Judicial Qualification Commission. We've got to have input throughout the whole judiciary. One thing Governor Miller, I give him credit, give him credit. He said to me, he said, as you negotiate this, you're going to get to a point where you're going to demand representation as it relates to appointments. And he said, you need to convince the African-American attorneys around the state, not just in Atlanta, Georgia, that they need to create an organization that will be on the same par as the State Bar Convention. And so after we signed the agreement, Zell and I had to appear at the State Bar Convention in Savannah, and the next day I had to come back to meet with black attorneys that were meeting there in Savannah. And I said, here's what we recommend you do. We recommend you form a statewide organization, elect your officers, and you call it whatever you want to call it. You all agreed, some of you were there. You said, we're going to form the Georgia Alliance of African American Attorneys. Tony Axon became the first president. And so you were able to get locked into this agreement in terms of being there as the state bar was in terms of appointments. So that's how that happened. But I was not willing to just say, just put a few more black faces on the benches across the state and not deal with the fundamental structure of how the judiciary works in Georgia. Now, we won the case. I thought it was a great victory to have that kind of a settlement with Governor Miller. We had all of our plaintiffs on the Fulton County courthouse steps one day. Then we went up to the state capitol, took a wonderful picture with all of us there. I think the Fulton County Daily Report ran the entire settlement that we had signed off on. Now, Zell Miller kept his word. Joe Frank Harris began to respond, even though we had not reached a settlement before he left office. Zell Miller kept his word and began to fill vacancies all over the state in certain judiciary circuits. Now, Roy Barnes came into office, and of course, Roy Barnes being the best governor we had in our history, we knew what he would do. And Roy Barnes began to appoint at a rapid pace. And so we began to realize from the Supreme Court, Court of Appeals, Superior Court, state courts, even down to magistrate courts, a total different atmosphere and a whole different reflection of how the judicial branch would look. Now, after Roy Barnes left office, we began to go downhill. As Charles has indicated in his slide and presentation, Sonny Perdue and Nathan Deal have just been bad news for us. And you know, the way it works, of course, is when you have a vacancy in a circuit, when someone serves out their term, you run. Across the state, African Americans are at a tremendous disadvantage because black lawyers do not get the support of the local bar associations usually. Therefore, they can't raise the money to compete. A lot of times you'll have judges to cut a deal and say, well, my time is about up, so I'm going to go ahead and retire early. That gives the governor an appointment. And based on your campaign contributions or which party you're in, you may or may not make the short list. That's just the way it works in reality. So we have not done very well since Roy Barnes left office.
There's no question that Tyrone played a major role in the litigation. In 1988, we filed a lawsuit and we raised basically two claims. One was that the state had created additional judgeships but had not submitted them for pre-clearance under Section 5 of the Voting Rights Act. They said they didn't have to do that. And then we had another claim in which we said that the method of electing these judges at large from judicial circuits violated Section 2 of the Voting Rights Act, which protects the equal right of minorities to elect candidates of their choice. Well, the litigation was very complex and the issues went up and down. On the Section 5 claim, we did get a decision from the Supreme Court that the adding judgeships was a voting change that was covered by Section 5 of the Voting Rights Act. But the voting changes were pre-cleared, meaning that the only claim we really had left was the Section 2 claim. At the time we filed the lawsuit, there were only 6 of 137 judges who were African American. And we knew that the state was divided into 45 judicial circuits, each containing between 1 and 8 counties, each electing between 1 and 14 Superior Court judges. We determined that if you went to single-member districts, that you could create a minimum of 25 majority black districts, meaning that the residents and voters in those districts could elect candidates of their choice, which would include African American judges. So we claim that the at-large system diluted Section 2 of the Voting Rights Act. Well, that issue sort of went up and down, and we met with Governor Zell Miller at the governor's mansion. I was at one of those meetings, and there is no question that the litigation had an enormous positive impact on the appointment of more African-American judges. However, while our case was pending, the Supreme Court had issued a ruling that Section 2 did apply to the method of electing judges, that you could bring a Section 2 claim challenging at-large elections for judges. However, there was a series of cases decided by the 11th Circuit. Georgia is in the 11th Circuit, which ruled that Section 2 did not apply to the method of electing judges. And the Supreme Court refused to review any of those cases. It wasn't just one case from the 11th Circuit. I think there were like 3 major cases in which the 11th Circuit said you could not have a Section 2 claim. So the Supreme Court refused to review any of those, so we know that we couldn't really proceed on our Section 2 claim because the courts would dismiss it. So that's where the Section 2 claim finally ended up. But as Tyrone points out, the litigation did have an enormous positive impact. And I will just close by saying that we're talking about judges, but the problem is more profound, infinitely more serious in Georgia and in the South. It was not just a selection of judges that was discriminatory, it was the entire judicial justice system. The prisons and jails were racially segregated. They didn't get desegregated until a lawsuit ultimately decided by the Supreme Court, Washington versus Lee, held that racially segregated prisons and jails in Alabama violated the Equal Protection Clause of the 14th Amendment. That was a very interesting case because the state of Alabama argued that the Equal Protection Clause as applied in Brown versus Board of Education, the school desegregation case, did not apply to prisons and jails because it said inmates, convicted felons, are not innocent school children, therefore equal protection doesn't apply. Fortunately, the 3-judge court which heard the case said that the 14th Amendment follows people into prison, and it invalidated the prison system. So we were subsequently able to use that decision to desegregate all the prisons and jails, road gangs, and so forth. So we had prisons and jails that were racially segregated. We also had grand and trial juries that were racially segregated. Blacks were not chosen. So you had all white juries indicting a disproportionate number of blacks for offenses, and they were tried by trial jurors that were selected from all white lists. So there were a lot of habeas corpus actions filed on behalf of blacks who had been convicted and sentenced to death. All of those habeas corpus actions were successful. I don't think any of them were not successful. We also represented black men and women who were eligible to serve on juries but who had never been summoned. All of those lawsuits were successful. The states finally realized they could not indict and convict people using racially discriminatory juries. So the state of Georgia finally enacted a law which is on the books, which provides that juries in a given jurisdiction must be selected from a list that represents all the people who live in that jurisdiction. So if you go, I mean, I've been summoned to serve on juries in Fulton County, and I've been impressed with how racially diverse the people who show up are, and I'm sure that's the case throughout Georgia, but it was not always that way. Also, it was not just prisons and jails, it was not just juries, but it was law schools. Georgia didn't have a law school that blacks could attend until, fairly recently, I mean, a number of years ago. So you had a bar that was racially segregated, and even when there was a law school blacks could attend, you had a white bar association and a black bar association. That obviously has changed now. But, we live in a system that has always been, tainted with race. And unfortunately, we still see that in the selection of judges. That there simply are not a proportionate number of African Americans who serve on juries, and we need to remedy that. And I'm glad to see that that's what this conference is all about. It's a huge thing we need to do.